And I'm recording the meeting, as it says. Okay, go ahead, Kelly.
Thank you, Mary. As Mary said, my name is Kelly Cruz. I am a principal with the Employment Law Group. We're a plaintiff side employment law firm, and I represent both private and public sector employees in claims against their employers. And in the past year and a half, many of those claims have been at least tangentially related to COVID. So I am happy to be here today to share some lessons learned with you. I put together this presentation kind of from the perspective of being an employer and what you need to consider when you're discussing this situation with your own employees. But some of you might be joining us to learn more as a practitioner. If that's the case, I'm happy to brainstorm with you if you have any questions about your own cases. Some of you may be joining as an employee with questions about your own employment. If that's the case, I'll be passing you my virtual business card at the end of this. But this is a small group, so please do feel free to chime in with questions at any point. And then I've also left some time at the end for questions. Just kind of a roadmap of what we're going to discuss today. I'm going to start by discussing the laws relating to the return to the workplace and what your obligations are as employers when you're making policies for your employees. I'm going to run through several scenarios that you may be experiencing with your own employees. This is based on my own experiences as an employer, plus what I've been hearing from potential clients. I'm going to run through some practical considerations that may not fall neatly within the laws that we're going to be discussing, but things that you should be thinking of nonetheless. And then, like I said, there'll be time at the end for questions and answers if there's something that you don't ask as we're moving along. All right, as employees begin to return to the workplace, you're going to have to put some thought into the policies that you may or may not yet have in place regarding telework, vaccinations, and then kind of the miscellaneous masks, sanitizing, and social distancing policies. You may not have had any telework policy prior to COVID. And this is something that you might need to be thinking about for the first time. Certainly, most of us did not have vaccination policies in place or things that we needed to consider regarding social distancing and masking. Do you have these policies in place, and are you going to need them? The federal law that applies in most of these cases is the Americans with Disabilities Act, and an employer has an obligation to provide reasonable accommodations to employees who are disabled. And the laws have been applied to vaccine exceptions and telework requests. Now, keep in mind, this is the federal law. If you are an employer in DC, the DC Human Rights Act applies. And in many situations, it provides more obligations to you as an employer. For example, while the ADA covers employers with 15 employees or more, the DCHRA covers employees with just one. So if you are a solo practitioner with the secretary, you are an employer under the DCHRA. I'm just going to take a look at this chat question. Okay. So once you learn that you have an employee who is disabled, you need to take a look at that employee's core duties. Can they be performed remotely? I'm just going to use some examples with our own employees. Prior to COVID, we had a receptionist. That receptionist job was to greet employees or greet guests as they came in the door. That is not a job that can easily be performed remotely. We also had several law clerks. What we have learned during COVID is that the law clerk's job can be done 100% remotely. So take a look at the core duties and, decide how does the disability affect the employee and how, if at all, can they be accommodated. Remote work may be one way that you do that. Some employers are considering going to 100% vaccination mandate for their workplaces. I've been hearing that once the vaccines are fully approved by the FDA, we're going to see a lot more workplaces that require vaccines. And in that situation, you're probably going to get some requests for exemptions to your vaccine mandate if you have one. They are probably going to fall under two different categories. One might be that the employee has a medical reason that they cannot be vaccinated. The other may be that they have a religious reason that they cannot be vaccinated. You're in the situation with the request for the medical exemption, you have an obligation to have an interactive discussion with that employee to talk about what safeguards you can put in place if they cannot be vaccinated. Perhaps that employee is going to have to wear a mask in the workplace even when the mask mandates are lifted. It is possible that that employee is going to have to be more socially distant from their colleagues than they were prior to COVID. The process for evaluating a religious exemption is somewhat similar, and in that situation, you're going to have to decide how comfortable you are probing your employees' sincerely held religious beliefs, but it still starts with an interactive conversation. For an employee that requests telework as a long-term accommodation because of a disability, and when that is an employee that you really like to have them come back to the office, it's the same process. You need to talk about how the disability affects their ability to do their core duties, and you may ask for medical documentation to support the employee's request. This is not a violation of HIPAA. I've really been hearing HIPAA as the most incorrectly cited statute lately. It is almost impossible for an employer to violate HIPAA, except in some very rare exceptions. But certainly you may ask for documentation from the employee's doctor to support their request. However, if you are an employer that's large enough to have an HR department, I would recommend as a best practice that the HR department should be the ones who are handling the medical documentation, and that medical documentation is not necessarily shared with the employee's manager. That's a best practice that protects you as an employer and certainly also protects the employee's privacy. So let's go through some possible scenarios that you may encounter when you're speaking to your employees. If you decide that your workplace is going to have a vaccine requirement, you may have an employee that comes to you and says, either I cannot be vaccinated because of a health condition, or because of my health condition, even though I have been vaccinated, I'm still at a higher risk. Keep in mind that as an employer, you cannot be faulted for failing to accommodate a disability if the employee fails to make you aware of the disability. They need to come to someone in management or HR and make them aware that they have a disability that needs to be accommodated. But also keep in mind that the employee is not required to use magic words in order to start that interactive process that I was discussing. So they are not required to come to you and say, I require a reasonable accommodation under the DCHRA or the ADA. So a best practice is to really train your managers on how to respond when an employee says something like, I am concerned about coming back to work because I have diabetes and that places me at a higher risk. Make sure that you have a policy and a protocol in place for how a manager should address that situation where an employee likely needs an accommodation or maybe needs an accommodation, but they're not using the magic words. And in the case of vaccines, if an employee is seeking a medical exemption to a vaccine, you may ask them to get documentation from their doctor that specifically lays out the medical condition that requires them to seek the exemption, because it's possible that they could receive one vaccine versus the other. If the employee has an allergy to an ingredient in one vaccine that's not present in another, then the accommodation might be that they use an alternative vaccine. Something that I've seen come up several times with clients and potential clients is that they have a mental health condition and returning to work would exacerbate their symptoms. The ADA and the DCHRA certainly do apply to mental health conditions. I had a case early on in Maryland where the client had a physical condition that placed her at higher risk for COVID-19 serious symptoms. And then that risk caused her to experience severe anxiety and panic attacks. So saying that I'm simply afraid to come to the workplace is not something that you need to accommodate under the ADA or the DCHRA. However, once it becomes a diagnosable condition for which your employee is being treated by a physician, it's probably going to be something that you'll need to accommodate. And the EEOC has specific guidance out on how to handle a mental health condition, really almost in the same way that you would handle a physical health condition. Going back to hearing an employee tell you that they have a religious objection to being vaccinated, certainly if you decide that you're going to accommodate the employee for that reason, you still can take precautions to protect your other employees and your customers. That may involve continuing the mask mandate for that employee. You may require them to be tested on a regular basis. You can reassign them or place them in a location where they're physically distanced, even that if that is not ideal for the employee. And certainly during the pandemic, we've been hearing from several people who are pregnant. Pregnancy is not necessarily in and of itself a disability, but certainly as we're hearing now, as the Delta variant is spreading, pregnancy can certainly put an employee at greater risk and may turn into something that is considered a disability under the ADA. My advice to people, or to employers, when they're evaluating an accommodation request for a pregnant employee would be to engage in that same interactive process, but keep in mind that unlike many disabilities, pregnancy is a temporary condition. So you may want to consider whether you can allow that person to continue to telework temporarily during the pregnancy, or if the person is concerned about getting the vaccine and you have a vaccine mandate in your workplace, maybe allow them to telework until the pregnancy is ended and they're more comfortable getting that vaccine afterwards. In our office, before the mask mandate came back, we had the policy that employees were not required to wear masks if they disclose their vaccine status confidentially to HR. And we had a couple of employees who told us that they were not going to be vaccinated or they were not comfortable doing so. So the response to that is simply that we as an employer at this time are not requiring vaccines, but you are going to need to require to wear your mask when you're in the office. And I think that's how a lot of employers are handling this particular situation. As I said earlier, asking or requiring an employee to show proof of a vaccine is not prohibited by the ADA, DCHRA, or HIPAA. However, keep in mind that an employee's vaccination documentation or status needs to be kept confidential, meaning that the employee's status should not be shared with other employees. That is why if you have an HR department, this is a perfect role for them in order to keep that information confidential. However, if you are requiring that employee to wear a mask after the mask mandate is lifted, or if you're requiring them to work in some socially distanced location, that may have the result of outing someone as being unvaccinated. That's really just part of the balance that you need to strike when you're considering the health of your employees versus the privacy of your employees with their private medical information. And finally, you may have employees who tell you, I live with someone in the household who is immunocompromised, and I don't want to increase their risk by coming back to work. The ADA and the DCHRA do not require a reasonable accommodation in these circumstances. You may be aware that there is a provision under the ADA that prohibits an employer from discriminating against an employee based on their association with someone who is disabled. So, for example, if you know that your employee has a disabled spouse or child, it doesn't actually have to be someone that closely associated, and you fire them because that's just not something you want to deal with, that would be prohibited under the ADA. However, that provision does not require the employer to accommodate a non-disabled employee who has a relationship with a disabled person. You may have employees who moved to a different state during the pandemic because they were working remotely and it's something that they could do. I have certainly heard of this happening within our firm, but from potential employees as well. They've moved to be closer to family. They've moved to someplace that they've always wanted to work. They don't want to work in DC anymore. They want to continue their employment on a permanently telework basis. You as an employer are allowed to choose to only employ employees in certain states because you need to know that you are subject to the laws of the states where your employees are working. I have heard some horror stories from my colleagues on the defense side of the employment law bar about employees who moved without telling their employers, and suddenly the employer is now subject to the workers' comp laws in New Jersey when they did not even know that they had an employee in New Jersey. So this is something new. You may need to make a policy that remote employees must notify you before moving to a different state. You are allowed to choose where your employees are located, even if you are an employer that allows permanent telework. And finally, you may have some employees who just do not want to come back. They have really enjoyed teleworking, and they do not have a medical condition that would prohibit them from coming back to the office. They just want to telework. You can decide whether you want to accommodate that kind of request or not. The law does not prohibit you from telling employees that they need to physically return to the workplace as a condition of employment. Well, those are the laws that outline your requirements as an employer, but let's also talk about practical considerations that you might want to be thinking of as well. If you have employees with young children, that would be children under the age of 12, they cannot be vaccinated yet. And many parents may be concerned about exposing their unvaccinated children if they're coming back into the workplace and then coming home to their children. With schools and daycares opening up, the protections that were there at the beginning of the pandemic are not quite what they were. And while some of these parents may have protections under the FMLA and the DC FMLA, being unvaccinated in and of itself is not a medical condition for which they would need to take FMLA leave or be entitled to take FMLA leave. So you are going to have to decide for those employees with young children if you're going to continue to allow telework until those children can be vaccinated. I spoke on the last slide about employees who just don't want to come back. They really enjoy telework. Certainly, as I said, you can require them to come back, but I think what we're learning anecdotally is that many employees, if they got used to telework and they really love it, they might be willing to leave and find a new job that will allow them to continue to work from home. So this is just a practical consideration. How much do you value that particular employee? Are you going to allow them to continue to telework? And then take a look at your policy and make sure that it's being applied uniformly. What about a hybrid workplace? So let me tell you a bit about what our firm has done. It's certainly not a one-size-fits-all situation. Your mileage may vary. When we were looking at bringing employees back into the workplace, we started out by sending surveys, anonymous surveys to the employees. I have also heard of some bigger law firms doing focus groups, which I think is also a great idea. They've been, focus groups have been handled by outside vendors so that the employees feel that they can speak freely on what their preferences are. When we sent out those surveys, we learned that some of our employees were very eager to return to work. They missed seeing people day to day. When they were at home, they felt like there was no change from their workday to the evening when they had time to do things for themselves. We also had some of those employees that I discussed who absolutely loved working remotely. They didn't miss their commute and said, if they were allowed to work remotely, they would probably never come into the office. For most of our staff, we were fine with that. In the past year and a half, we've found that performance for our employees who have been working remotely has generally been very good. Billing has been very good. We didn't have any reason to tell them we're going to force you back into the office if you would prefer to work from home. But we needed to consider, do we want to hold open office space or cubicle space for someone who's going to be in the office very rarely? So I put up a screenshot here of a website that we use. There are many different apps or websites that you can use if you want to consider this kind of hybrid workplace. We have assigned offices for our principals, assigned offices for some jobs that can't easily be done remotely, like accounting, HR, and reception. But for our associates, for our legal fellows, and for our law clerks, we have offices that people can book if they want to be in on any particular day. They go into this website, they book a particular office, and many of them are shared spaces, but if there's only a handful of people in that day, you can have an office all to yourself. Also, my partners and I make our own offices available if one of the law clerks would like to work in our office on a day when we're not in. So if you're going to be looking at a hybrid work situation, you need to consider workspaces and how you're going to make the best use of your very expensive DC real estate. Certainly, there are probably a couple of jobs in every law firm that cannot be done remotely, like reception and like the person who handles your mail every day. Also, obviously, you need to be staying up to date on changing guidance about mask mandates. Like I said earlier, we lifted our office mask mandate a couple months ago, but now it's back because we're complying with DC's requirements now. So after I step out into the hallway after this presentation, I'll be putting on my mask to head to the kitchen. All right. What questions can I answer for any of you?
Yeah, if anybody has a question, they can go ahead and unmute themselves or go in the chat. I had a quick question, Kelly, even though I don't practice law, it popped into my head when you spoke about the person who had moved to New Jersey without telling their employer. Well, what about somebody who does that for a month? Like say they're up in New York for a month. When does the law kick in those cases?
That varies state by state. And this is something that employers are learning the hard way. So I think, as a best practice and something that we're going to be doing moving forward is if an employee is going on vacation or they're going to be working remotely we have a lot of young employees. So if they're going to be working remotely from their parents' house for a couple of weeks, we don't consider that to be they are moving. But if they're going to be going away for the summer or something like that, we need to take a look and research the laws in the place that they want to move. Right now, we have an employee who has asked us, and he's an IT employee, his job can certainly be done remotely, and he would like to move home to North Dakota. So we're doing some research right now on what are the laws that we would be bound by if we have an employee in North Dakota. But it's definitely a state by state issue and something that employers have not had to deal with prior to COVID when everybody started to work remotely.
Yeah. Okay. Well, that's something definitely for everyone to consider, especially when they have people who might be going home for a month or two. And then it looks like Tracy has a question. Can you elaborate on the requirements of the DC mask mandate?
So the mask mandate as it stands right now, it's an indoor mask mandate. And because I am sitting in my office right now with the door closed and nobody else is in here with me, I can have my mask off. However, if I want to step next door and have a conversation with my colleague in his office, we need to be wearing our masks. If we want to have a meeting in a conference room, we need to be wearing them. And if I'm in the shared spaces of our office, the kitchen, the hallways, the elevators, restrooms, at this point, we need to be wearing our masks. I don't think that's going to last forever. They lifted it for a while, but that is the rule as of today.
Okay, there's another chat question. Can you see that,
Yes.
Kelly?
Now,
From Noah.
Yeah, if office assistants who are vaccinated work in a shared space and choose not to wear masks, does the employer have an obligation pursuant to a DC mask mandate to require them to wear masks in a shared space? The answer as of today is yes. The mask mandate in place in DC right now requires masks in a shared space regardless of vaccination status. For what felt like a very brief period of time, that was not required. I'm hoping we are going to get back to that point again soon.
Yeah, I imagine it can be difficult and awkward in the situation that Noah brings up, when you're in these groups and certain people are taking their masks off in an employment situation, like having somebody in the office, I guess, who is the mask police, actually, it's just, it's a tough one. Yeah.
And
All right.
I would be happy to share the guidance that we sent out to our employees, but really we leaned upon the fact that, first of all, this is what the District of Columbia is requiring of us right now, and we're going to follow it. Also, we rent a space in a large building, and the building is requiring us to comply with these mask mandates. So this is not something that we're just doing to make you employees feel uncomfortable. We're following the law, and we're following what is required of us as tenants as well. And we need to follow what our landlord requires.
That's a great objective way of stating it. Okay, Matthew Nace has a question.
When interviewing a potential employee, are there questions that are problematic issues that you are aware of as far as the extent of what you can and cannot ask? Yeah, I would, as an employment law attorney, I would avoid asking questions about a person's vaccination status or any disabilities that they might have. Certainly, you can share with the employee, these are our policies. For example, we require all of our employees to be vaccinated. You can share with them, we do not have a widespread telework policy. We require our employees to work in the office. And then, like I said, you cannot be held accountable for disabilities that you're not aware of. So if the employee is going to have an issue with that, maybe they have a medical condition that prohibits them from being vaccinated, or they have a disability that needs to be accommodated, it then becomes the employee or potential employee's responsibility to raise that with you. And then the burden goes back to you as the employer. Can you accommodate that disability so the employee that you've selected after you're done with the interview process can work successfully in the role, whether that means telework or something else. But I would not recommend as a practice to be asking people about their vaccination status or any disabilities that they have during the interview process. And that's kind of tailored to what we're discussing here today. There are obviously many other protected categories, especially under the BC Human Rights Act, that you are not going to want to get into as questions in an interview, like marital status, parental responsibilities, sexual orientation, not questions that I would recommend asking in an interview.
Does anybody else have any questions? Oh, Tracy, go ahead.
Yes. If someone contracts COVID in the workplace, does workers' compensation kick in? Possibly, yes. But there is going to be kind of a conversation about how does the employee know that they contracted COVID in the workplace? And is there some other location that they might have contracted COVID? Did they contract it from someone that they lived with? Were they out in a bar on Friday night with their mask off? So possibly workers' comp could kick in, but the guidance from the Department of Labor has been that there's going to be an inquiry as to how the employee actually knows that they contracted COVID in the workplace.
Any other questions for Kelly? Wait another minute, gives people time to type if that's the case.
Yes, I would be happy to share the PowerPoint. I will have Mary circulate that for you. I'm also going to put I see that I didn't put my email address on
Oh,
yours.
okay, great.
In the
Yeah, maybe you could just share that. Yep.
chat, and I would be happy to speak to you if anyone has any follow-up questions on the law or just practical considerations on how to handle this very new situation for all of us.
Great. And there's Kelly's email. She has shared there. Give everybody a moment to write that down. Wow, this has been really fascinating. I work by myself here, but I know so many of the members have these questions as employers and employees. So thank you so much for sharing your knowledge on this, Kelly. It was really fascinating. And with that, I'm going to sign off. This has been recorded. So those of you who signed up and want to look at it again, I'll make the recording available to you as part of your purchase. Okay, with that, goodbye, everybody. Have a wonderful day. Thank you for joining. And thanks again, Kelly. Bye-bye.